All right, guys. Welcome in. We might have a few, latecomers coming in, and that's all right. But we like to get started on time so that we can be mindful of everyone's time and get the information out. Everyone will be receiving a recording of the webinar afterwards, so that's all right. So just a few housekeeping items first. My name is Kayla Williams. I'm project coordinator here at SHRM Group, and I'm moderator of our monthly webinars. And you are here for the What Are HR Facts and Myths? These are key employment regulatory updates for 2024 as we go to enter into this new year. This webinar is brought to you by JER Group and our Trainery Brand Solutions. So JER Group is a national human resource firm with over 30 years of experience providing compensation consulting, employee learning, organizational development consulting, and HR services and support for over 300 clients nationwide. Our team of staff and consultants work collaboratively with our clients to develop and provide custom solutions that align with client needs and strategies. After the webinar, again, you're going to receive a recording of the webinar as well as a copy of our PowerPoint presentation via email. You generally get that. So it's a Friday, of course. You'll generally receive that no later than Tuesday. And now, not everyone has utilized Zoho before. Most people are used to Zoom. So I like to just go over a couple of things. On your screen, you're probably seeing myself. I'm not sure of the order, so I might get it wrong, but you're probably seeing myself. Becky might be below me, and then below that's going to be Miss Teresa. And then below that, or over to the side, you're going to see our PowerPoint, and then there's going to be a little bar. On that bar is going to be video and audio. Those are probably grayed out for you. We do not allow video and audio for our participants in the webinar. I apologize about that. But you should see a couple of things here. First off, the Q&A, where you can access that. It looks like a little question mark. Second off, a little smiley face. That's for reactions throughout our webinar. So you can give us a thumbs up, a clap, if you really resonate with something that's going on here. And then there's going to be a button that has 3 dots on it. Yeah, there we go. Yes. And there's 3 little dots on that button. In that setting, you can actually change where we are. There's a couple of layouts. So if for some reason you're not seeing us correctly or you're having any trouble with your settings, you should be able to find your settings right there in those 3 little buttons. There should be all sorts of settings within there. If you have any questions, you can always reach out in the chat, or if you have any issues. So without further ado, this morning's presenters are Miss Becky Page. She is our Director of HR Services, and Miss Teresa Friel. Did I say your last name correctly? Because I never asked. I did. Wonderful. I got it right on the first try. That's fantastic. And she is one of our senior HR consultants here at JER HR Group. So I'm going to go ahead and turn it over to you guys to get us started.
Great. I don't know if I heard Teresa. Can you hear Teresa?
Teresa's on mute. I saw her shake her head, but she's on mute.
Yes, you pronounced it correctly. Thank you.
Okay. All right. So I just want to say happy Friday, everybody. I always tell all the younger people, I go, I don't know what happens when you get older, but it seems like it takes forever for Friday to come, but the years fly by. So watch out. Yeah, watch out for you younger people. That's what happens. But happy Friday, everybody. I want to take a quick second again to really thank you for your time. We know how valuable time is, and we're really looking forward to this webinar. So as Kayla mentioned, my name is Becky Page, and I am the Director of HR Services with JER HR Group. I've been in HR for 30 years, and including owning my own consulting company for 20 years. So I'm just going to let Teresa just introduce herself real quick, and then we're going to move on and get started.
Good morning, everybody. And happy Friday. Becky was right on with that. It seems like it takes forever to get to Friday, but yet it's like, what? It's already like the end of the year. My name is Teresa Friel again, and I've done HR consulting for many years, probably 12 years of consulting. And then I've actually been in HR since 1996, so several years. And before that, I worked for a personnel agency where we placed temporary and full-time employees. So welcome. I'm excited to kind of go through some of these new laws for you, and certainly, hope you feel more prepared going into the first of the year. But certainly we'll be open to any questions that you might have, because they tend to be pretty detailed. So
Great, thanks. We are co-presenting today, so I'm going to start off and then I'm going to hand it off to Teresa. Also, we will be turning off our cameras so we can focus on the presentation. So I'm going to stop my video and we'll start with the agenda. So creating the agenda for today really was difficult. There's so many laws, employment laws that, all employers really do need to have a basic understanding. But, we only have so much time. So we tried to narrow it down to the most current and kind of the most, misunderstood. So what we're going to go over today is a couple facts and myths. The next thing we're going to talk about is independent contractor versus employee. We are going to talk about harassment. We're going to talk about the National Labor Relations Board. We're going to talk about the Pregnancy Workers Fairness Act. Also providing urgent maternal protections, which is referred to as the PUMP for Nursing Mothers Act, and then trends in employment laws. So next slide, and we'll jump right into the facts and the myths. So I just did a couple here. One we still kind of hear of, so that's why I kind of want to throw it on there, is the statement says, I can have a policy telling employees they cannot discuss their wages. This is a myth. The fact is, the federal law of the National Labor Relations Act, in its Section 7, includes the right for employees to discuss wages, hours, and other terms of condition of employment with coworkers. In addition, there are several states that do include and have their own laws that protect employers the right to discuss wages. So everybody really needs to check their handbook. If you have anything like that in your handbook, you want to remove it. The next one is, I'm an at-will employer and can fire employees for any reason at any time. Although this isn't a myth, this is a misconception. So while it's true that, you're an at-will, you may be an at-will employer, and it generally allows employers to terminate employees for various reasons, there's a ton of exceptions. So, employers can't terminate employees for, discrimination for legal reasons, like discrimination of protected classes, or in retaliation of exercising certain rights, such as filing a work comp claim. And I will let you know, in our experience, the longer you wait to counsel or provide a performance improvement plan, it seems that employee challenge always seems to turn or can be perceived as discriminatory. So you really want to address the challenge immediately. For those of you that have seen Teresa and I in other webinars, we always, and you'll hear us throughout this, is document. So address performance challenges. That's the tip immediately, and make sure you document. You want to make sure also you're following the best practices and you're consistent when enforcing these policies. So where we see a lot of breakdown is at the manager level. So let me give you an example of consistency. One manager may fire an employee for one no call, no show, and there'd be a manager in another division that fires an employee on their third no call, no show. So that's very inconsistent, and an employee could make a very easy claim that the company is being discriminatory. So those are the two biggest things, and we're going to go to the next slide. This is where we need your participation. The question is, what is the number one EEOC charge? This is a poll. The first option is retaliation. The second one is disability, and the third is age. Just if people aren't familiar, the EEOC is the Equal Employment Opportunity Commission. This is the federal enforcement agency for Title VII and other federal protections. So we'll go ahead and give you a minute here, and Kayla, you just let me know when the results are in.
Perfect. Looks like everybody's just coming in. Give everyone a few more seconds. We have almost everybody has voted. We have about 80%. So I'm gonna give you guys a few more seconds. Get those votes in. We're almost there. Awesome. All right. So I'm going to go ahead and close this and publish these results. We have there's 100 attendees right now and 84 voted. So this is wonderful participation. Thank you guys. And Becky, you should be able to see in the polls. You should be able to see those results right there.
Oh, I guess I can't see them. Where are they? Just go ahead and read them to me. I don't see.
That's okay. We had 42 out of 84 voted for retaliation, 20 voted for disability, and 22 voted for age.
Well, great job. Of the 42, retaliation is the number one EEOC charge. It sits at 56%. Now, having said that, disability is number two. So, and we see that increasing quite a bit. So the top five are retaliation, disability, race, sex, and age. So just to give you a little background on retaliation. So retaliation can be in the form of termination, once again, document, demotion, withholding opportunities, promotions, harassment, things like that. So great job. That you're aware that retaliation is one of the charges that are most frequent at the federal level from an employee. So thank you so much for your participation. That was great. All right, next slide. Now we're going to talk about independent contractor versus employee. Now the distinction matters as it can have legal, tax, and financial implications along with operational challenges on how your workers are managed. Before I move into this section, I want everybody to keep in mind that certain states may have a narrower definition of independent contractor. And the best rule of thumb is if you're researching employment laws, you want to start with your state. In some instances at the county level, but with independent contractors, start at the state level before checking federal law. So the definition of an independent contractor is a person or entity that's hired to perform a specific task or perform services for another entity, but they operate as an independent business rather than an employee. So the key distinction between independent contractor and employee lies in control and independence in how the work is performed. This is a big gray area. The U.S. gray area sometimes for employers. The Supreme Court on a number of occasions have indicated there's no single rule or test to determine whether an individual is an independent contractor or employee for purposes of the Fair Labor Standards Act. So, but the court has held that it looks at the totality of the activity or the situation and where the employee lies in that level of control and independence. So among some of the factors they look at is, I'm just going to read through some of them and see if they kind of jump out at you. But number one is the extent to which the services rendered are an integral part of the principal's business, the permanency of the relationship, the amount of the alleged contractor's investment in facilities and equipment, the nature and degree of control by the principal, the alleged contractor's opportunity for profit and loss, the amount of judgment or foresight in the open market condition, with others required for the success of the independent contractor, and the degree of independent business organization and operation. So as I talked about, this is kind of what the U.S. Supreme Court has looked at in totality. So let's kind of drill down and look at some of those factors. So some of the factors that are kind of specific is if you look at instructions. So workers who comply with instructions as to when, where, and how they work are definitely going to be more likely to be employees than independent contractors. One area that a lot of employers aren't aware of is that they can look at training. So independent contractors are supposed to know how to do their work, and so they wouldn't need much, if any, additional training. So you want to keep that in mind. Independent contractors are typically paid by the job that they're hired for. And another area they kind of look at is expenses. Workers whose business and travel expenses are covered by the business are more likely to be employees. Additional factors you want to look at is tools and materials. Workers who use equipment provided by the company, they work for are more likely to be employees. And one that I know I mentioned before, but I just want to reiterate is kind of the set of work hours. Workers who say you have to work between here and there, the independent contractors generally can work whenever and wherever they wish. So in the summary, as we said, there's not a single rule or test. You want to look at the totality of the relationship, kind of the degree of the control, the nature of the relationship, and financial obligations. So you want to make sure that you really consider all these factors and properly classify. Now, be careful if you say, if you think that's not going to happen to me, everybody does this. This was quite a few years ago. I saw where there was a company with just 2 W-2 employees and 5 independent contractors. One of the independent contractors reported them, and it was later determined that all 5 independent contractors were technically employees. The cost of this misclassification was significant for the small organization and included penalties, potentially back pay, and taxes. So before we move on to the next section, I want to just kind of give a tip. Document your analysis of why you consider the worker an independent contractor. Once again, back to document. One of the most important is have a well-written agreement that's been reviewed by an attorney. Some of these agreements are contractual in nature, and so you may be bound by them if they have contractual language. And then when in doubt, you just want to err on the side of making the employee a worker. All right, so we're going to wrap that up and go to the next slide of harassment. So harassment is the form of employment discrimination that violates Title VII of the Civil Rights Act of 1964, which is unbelievable. It's going to be 60 years old next year. Also, the Age Discrimination Employment Act of 1967 and the Americans with Disabilities Act of 1990. As I mentioned before, the EEOC is responsible for the enforcement. So the EEOC says harassment is unwelcome conduct that is based on, and this is at the federal level, race, color, religion, sex, which includes sexual orientation, gender identity or pregnancy, national origin, and national origin means, most of you know, that's where you were born, older workers, and older workers are considered beginning at the age of 40. So that surprises a lot of people sometimes. Disability or genetic information, and that's including family history. Once again, you want to check with your state. There's many states that have additional protected classes, such as marital class. Now, when harassment becomes unlawful in 2 scenarios, and the first one is enduring, the offensive conduct becomes a condition of employment, which is known as quid pro quo, this for that. Luckily, we don't see much of that hardly at all, which is a good thing. The second one is, the conduct is severe and pervasive, and I want you to remember those words, severe and pervasive, enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. This is known as hostile work environment. I'm going to pause here and talk about a specific state. It's really important to note that a significant change has happened in the state of Colorado. The state itself has passed a law called the Power Act, and they have redefined the definition of hostile work environment. They have removed the words severe and pervasive. Therefore, if you're an employer in the state of Colorado, you have to be extremely mindful. If you have any type of employee complaint, you need to make sure that a proper investigation and identify if this complaint would fall under the Power Act and your new policy. Also, an FYI to Colorado employers, this law went into effect this fall. You will need to update your language. And the reason I mention that is there are some interesting things that are happening in Colorado that the federal government is actually reflecting in their bills and in their policies and in their current legislature. So, all right, another part of harassment is anti-discrimination laws. You know, this is a big one, and we're going to talk about retaliation, so it's going to tie back to the poll, is it prohibits against individuals in retaliation for filing a discrimination charge, for testifying, or participating in any way in an investigation, proceeding, or lawsuit under these laws. Or if they're opposing employment practices that they reasonably believe discriminate against individuals in violation of these laws. So there's some interesting things to note. The harasser can be obviously the victim's supervisor, but it can be a supervisor in another area, a coworker, or a non-employee. So keep that in mind. Also, the victim doesn't have to be the person harassed. It can be anyone who is affected by the offensive conduct. And unlawful harassment can occur without economic injury or discharge to the victim. So retaliation, and they spell this out pretty detailed. So I kind of want to just go through a few. So adverse reaction taken against an employee because he or she complained of harassment or participated. You've done a salary reduction. There's a negative performance appraisal, change in duties. And, you know, when an employee complains, you know, you must take action because, you know, that employee may view it as a punishment or retaliation, or you must not take any action that the employee can review as punishment or retaliation for filing the complaint. So, all right, our tip on this is, you know, we are seeing a lot more employees' claims of harassment and discrimination. So you really want to make sure you have a solid policy in your employee handbook. You need to have a clear understanding of the steps you're going to take in an investigation. Train employees on a harassment. Again, there's some states that actually require this. And most of all, train your managers on how to respond. Kind of as I said before in, you know, applying policy is you really need to make sure that you educate and prepare your managers for these types of situations. All right, so we're going to move on to the next slide. Okay, we kind of the last minute put this in the webinar, and some of you may have heard something about this in the news. It'll say, you know, time to update your handbook. This came from the National Labor Relations Board. The board is the enforcement arm of the National Labor Relations Act. So like the EEOC is for Title VII, the board is for the NLRA. This is called the Stericycle decision. So I'm first going to read this quote, and then I'm going to try to simplify it for everybody. So the main takeaway quote is that employers should review all policies that regulate employee behavior and conduct in light of business purpose the employer wants to achieve through the policy. Carefully defining the business purpose will help employees craft specific policies that meet specific business purpose. This is the thrust of the Stericycle decision. So what does this all mean? So I'm going to try to simplify this of a very complicated decision, but I'm going to give you a little history first. The NLRB has, has 5 members. So with every administration, they appoint 3 new members. There has been a back and forth on this subject, depending on what administration is in office. But as of now, since the Stericycle decision, the big picture has to do with employee policies that target specific behaviors that violate policies, and that there may be need to clarify some of that language. For instance, if you have a social media policy and you just use the words, "Don't be disrespectful," you may want to reword it using terminology of obscene, abusive, profane. We're going to be providing more information on this decision in our newsletter, and we hope to have a webinar on this specific decision with an attorney as a guest speaker in the near future. So more to come on that. But I do kind of want to piggyback, and I know this isn't on the agenda, but when you are, it's just good practice when you are referring to these terms to be more specific. I know when you're doing performance appraisal, or let's say you're doing a write-up and it's about employees for having unprofessional conduct, you always want to be specific about what that conduct is. So let's say somebody had a tone of voice. You want to say your tone of voice appeared dismissive, suggested a lack of interest, per your statements that you said you are overreacting, not a big deal. Disrespectful is used a lot. So you want to be very specific. So, you used a disrespectful tone, and that meant you were interrupting colleagues and you refused to collaborate. So that's just kind of a good overall tip, whether you're writing policies or writing performance improvement plans. So, all right, I think that's it for me. Do we want to pause, and do we have any questions before I turn it over to Teresa? Or?
I haven't had any. Oh, hold on. I'm looking at this. There's a question that came into the Q&A. This article states disability claims have overtaken retaliation claims. I just passed this research to a client, so maybe we can research further into the ensuing days, and they did link it there.
Oh, good. I was looking at 2020 data, so I must have missed the most current. And that's a good point. Thank you for saying that, because I'd mentioned we're starting to see a lot of disability. So you really need to understand the ADA Act, what steps you need to take in the ADA Act. And we'll update our presentation and make sure we have the accurate information. But thank you very much, because that is very important. And like I said, we're seeing a lot of it. We actually have done a webinar in the past on that. If you guys would like to have another webinar at the end, we're going to ask everybody to say what topics they'd like to hear on specific areas in employment law. And we can certainly dive deeper into those. So, great. I'm going to pass it over to Teresa, and we'll take it from there.
Great. Thank you, Becky. Good morning again, everybody. So we're going to talk about the Pregnant Workers Fairness Act. That became a federal law June 27th of this year. And what that does is it protects employees and applicants of covered employers who have known limitations related to pregnancy, childbirth, or related medical conditions. Covered employers include private and public sector employers with at least 15 employees, as well as Congress, federal agencies, employment agencies, and labor organizations. However, I would like to point out that prior to this law becoming effective, more than 30 states and/or cities in the U.S. had already had a law in place under the Pregnant Workers Fairness Act, maybe a different name. So please make sure to check your state for additional requirements, as well as, employers, what's considered a covered employer. I know in Colorado, it's actually one or more employees. So again, it's you're probably going to hear this throughout throughout the presentation. Make sure to check your state law as well. So I'd like to go through, share some examples of what unlawful employment practices under this law might entail. So it would be unlawful when the employer does not make a reasonable accommodation to someone with those known limitations. And the employer cannot demonstrate that the accommodation would impose an undue hardship on the operation of the business. So if you are going to deny a reasonable accommodation, you do need to make sure that you are able to, provide documented details of what that undue hardship would be for your organization. It's also unlawful to require a qualified employee to accept an accommodation other than any reasonable accommodation that was determined through that interactive process with the employee. It's unlawful for employers that deny employment opportunities to qualified employees if that denial is based on the need of the covered entity to make reasonable accommodations to the known limitations related to the pregnancy, childbirth, or related medical conditions and qualified employees. Again, these opportunities, these situations do come up. So as Becky mentioned earlier, it's so important to make sure that you're documenting the reasons why, you are making those employment decisions. Also, is unlawful to require a qualified employee to take a leave, whether that leave is paid or unpaid, if another reasonable accommodation can be provided to that individual. So make sure that you keep that in mind as well. So if you do have, the opportunity to provide a reasonable accommodation, you don't want to just put that individual on a paid or unpaid leave. And then lastly, employers that take adverse actions in terms of conditions or privileges of employment against that qualified individual or employee because they requested or are using a reasonable accommodation. Again, documentation, if you are needing to document performance, attendance, you can do that. You just need to make sure that it's documented so that it doesn't appear as though it's a form of retaliation. Again, for those of you that had a law in place in your state prior to June, make sure that your state's guidelines, that you understand the guidelines around this law in your state. All right, Kayla, let's go to the next slide. All right. Providing urgent maternal protections for nursing mothers, or POMP. This covers employers with 15 or more employees with limited exceptions. And some states have similar or more stringent laws. Again, several states prior to April 28th did have a similar law in place. So again, make sure that you check at the state level to understand the guidelines and the requirements under this law. I think, Colorado, again, I bring up Colorado because I'm in Colorado, but it's for, one or more employees. And it seems as though the federal government took a lot of the same guidelines in Colorado. So you'll see that there's quite a few similarities with the federal and the Colorado law. So let's talk a little bit about the limited exceptions to this. Again, this could be, dependent on your state qualifications. So some exceptions would be crew members of air carriers, However, that's only in place until the end of December in 2025. Some employees of rail carriers and motor coach service operators. And there's also an exception under undue hardship for small employers. Employers with fewer than 50 employees that demonstrate for each instance an employee needed a nursing break that the requirement would impose an undue hardship by causing the employer significant difficulty or expense considered in retaliation to the size or in relation, sorry, I've got retaliation on my mind, considered in relation to the size, the financial resources, the nature, and the structure of the business. But again, make sure to check with your state laws because they may not include some of these exceptions. So let's talk a little bit about what the law entails. So employers are to provide reasonable break time for an employee to express human milk for their nursing child for up to 1 year after the birth of a child. Again, this is the federal law. Your state could be different. Colorado is actually up to 2 years after the birth of a child. The frequency, duration, and timing of the breaks will vary depending on the employee's needs. And any agreed upon schedule may need to be adjusted as the pumping needs exchange. So I'm going to provide an example of what that looks like. So an example may be that, a shift manager at a fast food restaurant takes 4 25-minute pump breaks each day when she first returns to work after the birth of her child. But those pump needs changes as her baby grows. And when the baby is 6 months old, she can reduce her pump breaks to 25 minutes twice a day. So this example shows, schedules of reasonable pumping time that this individual would need, and the employer should allow over the course of the year after the birth of this employee's child. Again, state laws are different. So Colorado is 2 years. So those needs may not change as quickly in other states. Another part of the law is that employers must provide a functional pumping space, which is a place other than a bathroom that is shielded from view, free from intrusion from coworkers and the public being able to come in and just walk in, and is available each time for the employee. This space must be functional to express breast milk, and it must contain a place for the nursing employee to sit and a flat surface other than the floor on which to place the pump. Employees must be able to safely store milk while at work as well. And this could be in a personal cooler or a refrigerator. Some states do require that employers provide a refrigerator for the employee as well. Some examples of spaces that do not satisfy the law would be a bathroom, as I mentioned before, a room without a place to sit down. That would just be considered not functional. A room with a window but doesn't have a curtain or blinds or anything, so it's not considered a private space. A conference room that an employee may use only if coworkers aren't using in the room. So that's, a space that may not be available each time an individual would need to utilize that space. Plus, that may be a space where, you're not able to lock the door and they have the privacy that they need. So compensation, pumping breaks may be unpaid only if the employee is completely relieved of duties. If an employee uses regularly paid break times to pump, that's fine. That time must be paid at the regular rate of pay And then we all know it's a little bit different for our exempt salaried employees, that they cannot have their pay reduced due to pumping breaks. Enforcement. Employees can file Pump Act claims against their employer if that employer fails to accommodate them, or retaliation of wage and hour division, or as a private cause of action. Again, for those of you that did have a pump law or similar law in place in your state before April, make sure that you understand your laws, your state laws guidelines. Also, it's important that you update your handbooks. If this law is new to you and new to your state, make sure that you include these policies in your handbook as well. And we can help with that if need be. All right, next slide, Kayla. All right, trends in employment law. We're seeing paid family leave as a requirement in states. So this is certainly trending. What paid family leave is, typically, it provides an income protection that benefits individuals to bond with a new child, whether that be newborn, adoption, or foster placement, care for a family member with a serious health condition, in some cases to tend to the needs of a military family member, the safety needs, organ or marrow donation, and also bereavement. And this paid family leave can run concurrently with FMLA. So for those of you that qualify for FMLA, we are seeing that this law will run concurrently with that. The reasons may be different for each state, so there may be times when it will not. Protected leave, if employer or employee meets the eligibility requirements. Again, that's going to be state specific on what that looks like. Currently, there are about 12 states actually that have a paid family leave mandated program in place. I know Colorado is one of those. And we started the process just a few years ago, and at that time there were only 7 states. So it seems to be moving pretty quickly. There are a couple of states that currently just have like a temporary disability insurance requirement in place. 8 states have an optional insurance plan in place, so employers can purchase an insurance option. There are a couple of states, New Mexico, Michigan, that are more than likely to pass and mandate this over the next couple of years. 14 states have actually introduced legislation since 2019. So you're probably going to see, a lot of those come to fruition in the next year or so. There are, a number of states that are interested in providing some kind of voluntary optional insurance plan where the employer can implement those. And then, the remainder of the states just haven't shown any interest or haven't introduced any programs within their state. Let's see. Again, it is important to make sure that you check with your state level, because if you do already have a paid family leave in place, however, or if you're, in the process of implementing one, we do see that, the reasons for the leave and some of the rules around that leave can be different from state to state. So if this is not in your state yet, make sure that you keep an eye out for information from your state legislative leaders. All right, Kayla, let's go to the next slide. So similar to paid family leave is the mandatory paid sick leave. Currently, you know, approximately 20 states actually have a paid sick leave mandated program in place. Not all of them are statewide. Some of them may just be limited to cities within that state. And some of the reasons that we've seen for the use of paid sick leave, you know, some states like Nevada, any reason. You can use the paid sick leave benefit for any reason. Or for the employees or a family member's health condition. One thing that I did want to mention back with the paid family leave, again, that may be more state specific, is the definition of family member. I know in Colorado that definition is very broad and, you know, is not in alignment with, you know, for example, FMLA, what they define as a family member. So another thing to make sure that you're up to date on if you have a paid family leave or a paid sick leave policy in your state. It can also be used for need for diagnosis, care, treatment, or, you know, preventative care. So, you know, doctor's appointments and so on. Most of them include reasons related to domestic violence, sexual violence, or stalking. Just recently added in Colorado is due to inclement weather, power, heat loss, water loss, or any other unexpected occurrence. And the employees needs to either evacuate their residence or even care for a family member whose school or place of care was closed. And then that could be, you know, for a public health emergency. I know Colorado doesn't currently have a public health emergency, and I'm not aware of any other state that does, but, you know, some of the reasons could be that a public official closed the workplace or the school or place of care for the employee's child. All right, Kayla, let's move on to the next. Okay, so I'm sure we're probably all pretty familiar or have seen information coming out about the overtime rules and the 2023 FLSA overtime proposal. That proposal includes raising the salary threshold level for exempt workers under the FLSA to $1,059 per week, approximately 55,000, it might be a little over that, from its current rate of $684 per week, which is, you know, 35,568. So that's a significant jump. You know, again, state levels, some states do have laws in place where this threshold is considerably higher than the 35,568. So again, make sure that you're checking your laws at the state level to make sure that you're meeting those requirements. You know, no changes to the current duties test as of right now, other than maybe just more clearly defining you know, what those are. So the, you know, executive, administrative, or professional employees, maybe what that looks like. And increasing the highly compensated employee total annual compensation requirement to the annualized weekly earnings of the 85th percentile of full-time salaried workers nationally. Which could be over 143,000, almost 144,000 per year based on current data. We're not sure if this is going to be implemented. We've seen this come before under other administrations. However, just make sure that you keep an eye on it, and that you're aware, and keep in mind, maybe have some thoughts on how your organization would react to this change if it does come into place. All right, Kayla, that's it for me.
All right, next slide, Kayla. We just want to throw in some employer action items at the end. Once again, review the current independent contractors and ensure that you have a standard written agreement that's been reviewed by an employment attorney. No matter what state you're in, we suggest that you make sure update your handbook. Obviously, there's federal law changes in 2023, and then also have an ongoing HR resource for HR support and guidance. I know in the webinar, we talked a lot about checking the state law versus federal law. So the rule of thumb is if there's a conflict between the state law and the federal law, you need to choose which is most favorable to the employee. So you can't be like, well, I'm just going to follow the federal law and not the state law. So I kind of wanted to just touch base on that. Also, do we have any questions right now, Kayla?
Yes, yes. So I went ahead. I'm going to go ahead and put y'all's contact up here just so people can write this down while we're going over these questions. So as people were coming in with the questions, I told them, look, we're going to answer these kind of during our Q&A since we're going to have some time. Let's see. We had some questions roll in. So Graham, he just commented, he said, so the PWFA does not replace the FMLA. That's correct?
That's correct. Mm-hmm.
Awesome. And then someone else right below that said, can you clarify, did you say that under the PWFA, the employer is or is not allowed to deny requests based on undue hardship to the business?
Yes, so you can deny the request if you can prove and show that it does cause undue hardship for the business. You just can't deny it and then not prove that undue hardship.
Gotcha. And I think that rolls into what you guys were talking about, documentation, right?
Mm-hmm.
So, and let's see, George asked, and I think we did cover this, but just to clarify, so the pump breaks that we went over, those are paid or unpaid?
They are paid, under your recent or your current paid breaks. However, you can extend the time of the break, and that additional time can be unpaid.
Perfect. Let's see, a question from Laura. Can exempt employees be required to work over their regular scheduled 8:30 a.m. to 5 p.m. to make up for their pumping breaks, which are 4 25-minute breaks?
Well, I know this is kind of a good question. Obviously, exempt employees, you can have them work 50, 60 hours per week if you want. I wouldn't suggest that. But yeah, you can require exempt employees to work longer in the day if need be. I certainly, just from my perspective, I wouldn't do it just for the reasons to make up for that time.
Yeah, that could definitely look like retaliation,
Mm-hmm.
especially if they've had a set schedule from 8:30 to 5.
Mm-hmm.
Not suggested. Don't want to be a test case.
All right, so let's see. Is there a place that we can look at the duties test, or can I get them emailed to me?
Certainly. Yeah, we can email those to you. No problem.
Okay, perfect. And I can get that to you guys who sent that over. Let's see, Ronald, I apologize, but I had a question from the first slide you presented. Did I understand you to say that regarding Employee Relations Act, that I can have a policy telling employees that they cannot discuss their wages as a myth? Can you explain once more?
Yeah, so that was my area. So you cannot have a policy telling employees that they cannot discuss their wages. And it is under the Section 7 of the National Labor Relations Act. And that section gives employees the right to discuss their wages, hours, and other terms of conditions of employment with coworkers.
Perfect. Next question. When is the FLSA proposal going to be decided?
Well, Nancy, your guess is as good as ours. We're not sure when that's going, if it's going to move forward, or if it does, when that will be. They've been, I think we started receiving notices earlier in the year, right, Becky? That said,
Yeah.
oh, hold on, wait up, this
Yeah.
might be changing. Oh, it's going to be mid-year. Oh, it's going to be in August. It's going to be this fall. And it hasn't happened yet. So we're really not sure with that.
But one thing that has occurred is when they make these changes, they have to go out for public input. And that public input, I don't remember the exact date, it was November 7th or 9th, has stopped. So there may be some, decision or movement, at some point. So that part of the process has stopped. So, but we just don't know.
and it may be a higher wage as well.
Yeah, exactly.
I think some of that public input was to increase it from that 55,068 or 068 from there. So we could see it higher as well.
Awesome. And I just want to put out there, if you guys are not on our newsletter list or email list, definitely let us know. Because you signed up for the webinar, we can make sure that you're on that list. You can respond to your registration for this, and that does come over to me. I can make sure you're on there. We do send out updates for when these things happen. So we can make sure that you guys are notified. Hey, this has happened. This change is coming. And then the next thing is, will this be available offline as a recording? And you weren't able to hear, an employee came in. That's okay. We all have that happen. That's perfectly fine. So that's a question for me. You are all going to receive this as a recording. You'll get this via email. You'll also get the PowerPoint. That should happen early next week, no later than Tuesday. You'll have access to this. Let's see. And yep, another question about the recording. So you guys, you'll be able to see this and have access to that. And then there was another question that just came in. And I think we covered this, but just to repeat, because I don't think this person was here for this, doesn't federal trump state law?
Nope. So what it is whichever law favors the employee. So if the federal law says we're going to give, the employee 2 paid sick days, and the state says 3 paid sick days, you have to give the 3.
Oh,
I would
okay.
like to compare that to like minimum wage. I mean, you look at the federal minimum wage, it's so low. Most states have their own minimum wage, which is generally higher, quite a bit higher. So that would trump the federal minimum wage. So I always like to kind of give that as an example.
All right, let's turn our cameras on to say goodbye. Yay.
Oops, I'm trying.
Did I pop up? There we are.
There we go.
Thank you so much, everybody. Also, please, any and all feedback. We want to continue to improve. Send us suggestions of what employment laws you may need more education on. Any and all feedback is welcome. We really appreciate your time, and we're really passionate about just providing education. We know that this area is overwhelming. Sometimes it's overwhelming for us. So thank you for hanging in there with us during the webinar and attending. So do you have anything, Teresa?
Nope. Have a great
All right.
weekend.
Have a great weekend, guys.
All right. Have a great weekend, everybody. Thank you.
Bye.
Bye-bye.